corner and confronts them with even the most simplest of encounters. Because the evidence in this case has shown you that it was in the course of performing the most routine of tasks that Officers Curtis and Kokab were killed. That during the course of a traffic stop initiated by Officer Curtis because of a tag. Well, look at that. How do I reduce this? Well, that's all right. If you can just get it back on normal. During the course of a traffic stop, because of a bad tag, a photograph was established that was found in Courtney Brantly's car. This defendant, Dontae Morris, fired one shot into the heads of Officer Curtis and Officer Kokab from just inches. And if you remember the testimony of Dr. Krastowski, Dr. Krastowski told you that each officer suffered a similar injury. He described as devastating and unsurvivable. Dr. Krastowski went on to say that Officer Kokab's heart stopped shortly after having been shot. That Officer Curtis's heart remained beating for quite some time, even after transport. And Dr. Krastowski told you that he couldn't explain why the same injuries resulted in different cessation times for the stopping of the hearts. He said he couldn't explain that. He said he didn't think anybody could. Ladies and gentlemen, that's the only mystery that this evidence that you've heard presents. Because the evidence presented to you by the state of Florida clearly and unequivocally and emphatically proves to you beyond and to the exclusion of every reasonable doubt this defendant is guilty of first-degree murder, premeditated murder. And what the evidence shows you is that on the early morning hours of June 29th of 2010, shortly after 2 a.m., that as driving southbound on 50th Street, Courtney Brantly in a red or burgundy Camry, Toyota Camry, with her occupant in the front passenger seat, this defendant, got pulled over by Officer Curtis a few minutes after 2 o'clock. And in fact, the evidence shows you that at precisely 2:16 a.m. is when that stop occurred, and that within 5 minutes of that stop, this defendant took the premeditated acts that led to those officers' death. That Officer Curtis, as you saw in that video, approached the car, engaged in some conversation with Courtney Brantly about the tag. He obtained the driver's license from Courtney Brantly's driver's license from her. He obtained some type of vehicle identification information, and he engaged in a conversation that you've heard with the front passenger, Dontae Morris, who didn't have ID. And you know that he went back to his patrol unit and activated his computer and ran Dontae Morris with the name and date of birth that he was given. You know from the video and from the testimony of Alfred Thompson that as Officer Curtis was back in the car and there was a black male and a black female in that red Toyota, that Alfred Thompson was walking north on the sidewalk, northbound. And that within a few minutes of having walked by the officer's car, Alfred Thompson heard gunshots. The gunshots that took the lives of Officers Curtis and Kokab. And what the evidence has shown you clearly is at the time that this defendant killed the officers. He was wearing a dark vest. Showing you this exhibit was Exhibit K1, which is a still frame from that dash cam video showing Dontae Morris, the shooter, in the black vest with a white short. And that what you know from the evidence is that Alfred Thompson, when he heard those shots, he hid behind a red sports sedan that was parked in the parking lot. It separated apartments at 3212 and 3216 North 50th Street. That this defendant ran by Alfred Thompson and jumped the fence. You know that from Alfred Thompson, and you know that from Yanelia King, the young lady that testified early in these proceedings. And that when the defendant jumped that fence, showing you exhibits A97, he jumped the initial shorter fence and the larger one in back, A101, it shows you the larger fence. And if you recall the testimony of Yanelia King, she indicated she had not just a glimpse of him, but she looked out the front window of that apartment, which faced 50th Street, and saw him coming northbound on that sidewalk. And then when he came through that driveway, she went to that kitchen window and saw him again until she lost sight of him after he jumped the fence. And on June 30th, 2010, at 14:55 hours, 2:55 p.m., or about a day and a half after the shooting, Yanelia King identifies a photograph of this defendant, Dontae Morris, from the photo pack presented to her as the person that she saw running through that apartment complex driveway and jumping that fence. These events that occurred on June 29th of 2010 unleashed a search for Dontae Morris, and he was ultimately apprehended 4 days later on July 2nd of 2010. You have before you for your consideration 3 charges. 1 count of first-degree premeditated murder pertaining to the death of each officer, and an account of escape. The way it works in a criminal trial in Florida is, because the state of Florida has the burden of persuasion, of proving guilt beyond a reasonable doubt, which we accept, we get the opportunity to have 2 times to address you in closing argument. I'm going to speak to you just briefly this morning, or this afternoon. The defense will be allowed to address you, and then Mr. Harmon will close the summations with his comments, where he will address with you in far greater detail the issues of identity and premeditation, circumstantial and direct evidence that establishes not only the defendant's identification, but the direct and circumstantial evidence of premeditation that arises to meet our burden of proof beyond a reasonable doubt. That being said, I want to take a moment outside and away from the evidence and discuss one thing with you. When you're deliberating, you will be given a verdict form, and the verdict form gives you more options than just guilty and not guilty concerning the murders. And this is by law. You will have the options of guilty of first-degree murder and then guilty of other offenses. Now, when I discuss this to you, I discuss this with you with some reluctance, because I don't want you to think for a moment that I'm conceding that we have proven anything but guilt of first-degree murder. But I want to give you some suggestions on your deliberations. These are suggestions. You're not bound to follow what I suggest to you at all. But you will be instructed that if you return a verdict of guilt, it should be for the highest degree of crime that you have found the state of Florida has proved beyond a reasonable doubt. You'll be given a verdict form with a number of options, and I'll just take it for count one. We'll have guilty of first-degree murder as charged, guilty of second-degree murder below that, guilty of manslaughter below that, and not guilty. Each of the top two options, first-degree murder and second-degree murder, and actually manslaughter, have separate findings that you have to address about the use of a firearm. You have to determine whether, if you find him guilty of first-degree murder, he actually possessed and discharged a firearm and causing death. That has sentencing implications that are not really significant for your concerns, but you have to make a specific finding, whether one was used that caused death or not. The evidence is unequivocal. It's clear that a firearm was used and that caused death, and so that finding should be made. But what I'm suggesting to you is your deliberations should look at the evidence and determine, has the state of Florida proved beyond a reasonable doubt the defendant's guilt at count one, first-degree murder? If you find unanimously that the answer to that is yes, then your deliberations, I suggest to you, as to that count, stop, because there's no need by law for you to consider second or manslaughter. If, however, and I'm not conceding this, you find that we haven't proved that, then you go to second-degree murder and down the line to manslaughter. If you find, of course, that the state of Florida hasn't proved to you beyond a reasonable doubt his guilt at all, then, of course, the option is clear that that would be not guilty. I'm suggesting that to you because some, I think most of you had not served previously on a jury, and you're not going to be given specific instructions as how you deliberate. Mine are not instructions, because what the attorneys say is not evidence or law, merely a suggestion of how you merge the instruction with the verdict form. Now, ladies and gentlemen, you know, we spent with you, I think, a week of your time selecting a jury. We understand that you're here from another county, that we've disrupted your lives, we have disrupted your routines out of your obligation of service on this jury. And for the state of Florida, we want to express our consideration and our thanks for that, because we know it comes with some great inconvenience. I would ask that you extend your courtesy of your considered attention that you've shown me in the last few minutes to the defense when they address you, and to Mr. Harmon when he addresses you finally at the end of summations. Thank you.
Thank you. Yeah, that's true.
You guys all right?
Mm-hmm. Good afternoon, ladies and gentlemen. In a bit of echoing what Mr. Pruner said, that we want to thank you, and the court will thank you as well, for the time and attention that you've paid in this very, very difficult case. This will be my only opportunity to address you, and I'm not loud. I probably won't be yelling or raising my voice, but I'd ask you to listen and to pay close attention, as this is the defense's only comment upon the evidence that is permitted. Okay? At this point in our juncture, it's time for you as a jury to begin your work pursuant to that solemn oath that you took more than a week ago. You promised that you would follow the law. And after these closing summations, Judge Fuente will give you the law, he'll instruct you, And one of the things that he'll tell you is that your decision can't be based on emotion. He'll tell you that prejudice, bias, or sympathy play no role, that they're not allowed to play any role in your deliberations. And that's going to be extremely difficult because this case is one that is emotional. If you remember, and though it seems like a long time ago, as far back as jury selection, many of the prospective jurors were saying, oh, I can't sit on this kind of case. It's too close to me. It hits home. Even though you know that they were from Orlando, that they're not Tampa natives, and that their personal and close connection to this case was really, that there wasn't one. But we also know that this case is about the killing of 2 police officers. And I submit to you that whether you practice law as I do, pilot a plane, teach special needs children, or choose not to work outside the home and take care of a family, that nothing that anyone can do can undo the pain and loss suffered by the victims in this case and their families. Tough burden that you have to set all that aside and to decide this case strictly on the evidence. You have a tough job before you. I will begin by commenting on the evidence and start with the presentation of the case. The first person you heard from was Kelly Curtis, and she said she was the widow of Officer Curtis, who is a decedent in this case. Well, her testimony wasn't particularly emotional, but her person, and that she's here, and that she's a widow, was. And so you have to weigh such things and set such things aside. The next person you heard from on the witness stand was Officer Stephen Roy. And Officer Roy, in describing what happened, broke down, started to cry. Now, I'm not suggesting to you that he was acting or that his emotions weren't real. I point this out because your difficult job is to weigh the evidence without emotion. You took a solemn oath to follow the law in this case and to try this case. I believe the words you used were well and truly. Extraordinary measures have been taken to bring you from outside of Tampa, and that was done because this is such a tough, difficult job. Now, getting into the evidence, and I will speak to you about circumstantial evidence, direct evidence, eyewitness evidence. Okay? And in this case, you heard the evidence and testimony of many police officers who knew personally Officers Cocab and Curtis. And you have to, and they're human beings, and you have to weigh reliability. I'm not suggesting to you that any police officer intentionally misled you or intentionally tried to get you to go down a path that's not true. But when one has an emotional involvement in a case, and they all did, sometimes, and in Tampa, there was a pressure to find who was responsible for the deaths of 2 officers and to get that person and to get them to justice. And very difficult for the officers You heard from people who said, I worked with them, I've worked for the Tampa Police Department 29 years, 30 years, long time. Very difficult for them to be objective. You have to weigh through what they said and what they did to reach objectivity. That's testimony from persons. There's physical evidence. Physical evidence doesn't have a bias. It doesn't have a motive. It doesn't have any unintentional consequences, any unintentional communication. It just is. The physical evidence in this case would be fingerprints, DNA, things of that sort. You know, DNA is, and it is, and as it's said in the common vernacular, it is what it is, and that is the physical evidence in this case. Now, the first person you heard from, and I will address the evidence in chronological order, although when a case is presented, things are not necessarily done in a chronological order, but in the order that the witnesses testified. And the first person that you heard from was Brian Haight, and he said that he arrived at the scene after other officers were on the scene, that is the area on 50th, that there were many officers there, many firefighters and emergency medical technicians. And he says, and so we know that the initial goal of the officers at that scene was to provide assistance to the downed officers and try to get them medical help. And then, after they do that, then the detectives and the crime scene technicians come in and begin to investigate the case. Now, I tell you that, and you saw from the dash cam video that many people walk through the crime scene. Not inappropriate for them to do that, okay? Their first job was, okay, we get help for these people. But in terms of evidence, when you're speaking of evidence and want to present evidence, it is preferred, I would suggest, that the evidence be something that's pristine, that's not touched. And in this case, there were lots of people walking through the crime scene, and the officers told you, well, we couldn't, check footprints or things of that sort because there had been many. Now, you heard from Detective Eric Houston. Now, Detective Houston was called on that evening, and he said that he became the officer at the scene, the supervising officer at the scene, that his job was to supervise the crime scene technicians. And he arrived around 3:20. Now, it has been estimated that the time of the shooting was 2:16. Detective Hauser told you that no shell casings were located, that led the police at the scene to believe that the firearm used in this case had been a revolver. And he said that he was in charge of the physical evidence, that there was a zipper found on a fence, and there were photos of that, and that a dark red Camry was eventually located. Now, we'll talk more about the Camry and its evidentiary value in this case. The first civilian witness you heard from was Wanelia Keene. And Ms. Keene said she was going out for snacks at 2 a.m., that she saw the police car with somebody pulled over, and she heard shots, and she ran into the house, and she pulled her sister in the house, and that her mother told her to turn off the lights. But she said she could see out because the porch lights were on, and she was asked, where's your child? She said she had a child, and her child was in the house, and she said that her first instincts when she heard the shots was not to check on the safety of her child, but to look out the living room window to see what she could see, and when she couldn't see, she proceeded to the kitchen to look out the kitchen window. Now, she was challenged, saying, "Oh, did you make your identification based on having seen pictures of Dontae Morris on television?" And her answer was, "No, we don't have cable." As if the news regarding 2 local officers having been shot and killed was only on cable and not on regular broadcast television. But she said she made her identification. Now, mind you, unlike other witnesses, she wasn't asked from the witness stand if she could identify the person sitting in this courtroom as the same person she saw back in June of 2010. And indeed, she told you under cross-examination from Mr. Heilman that her memory was so bad. But let me show you something else. I have what was the state's Exhibit K that was used for identification purposes. Exhibit K purports to be a photo pack lineup that includes Dontae Morris. Take a look at this photo pack. Which picture on there is different than all the rest of them? You see how big these faces are as in reference to the actual frame where they're shown? And look at this one. It's smaller. If you didn't know anything about this case, if you hadn't seen anything, which one of those pictures stands out as being different from the rest? And this is the photo pack that she used to make her identification. And what's written on here, seen him at the Shell store, seen him on a back road with a group of people. He ran by my house when the police was shot. So, according to her, the police stopped this car, and somehow that person who did the shooting was outside of the car on a back road with a group of people. And that person also was at the Shell store. And then, I suppose, somehow got back in the car or whatever, and the incident occurred, and then that person ran by her home with police officers. Now, you're the persons who weigh the evidence. You're the persons who decide what evidence is reliable. Of course, Ms. Keene, when she came into court and was questioned critically about what she saw and how she saw it, because remember, she spoke about him jumping over the fence, jumping over the gate, said, "My memory is so bad." The next person we heard from, civilian witness, was Alfred Thompson, Jr. Alfred Thompson said he saw a car pulled over with lights on and that there were people inside it. He didn't see the people get out of the car and go to the Shell store or be on the back road with a group of people. And he said as he was walking by, he heard shots fired and he hid. And he says he saw a black male jog by, but he couldn't say who that was or make any kind of identification. And he said he stayed where it crouched behind a red car you and I know, but he didn't know, that that was Miss Keene's mother's car parked in front of their apartment, that he didn't see a guy jump any kind of gate, and that he stayed there until the girls came outside of the apartment. That would have been Miss Keene and her family coming outside of the apartment. His memory is that the person who jogged by him had nothing in his hands and that he was wearing full-length pants. That was what you heard from Mr. Thompson. The next civilian witness you heard from was Tamika Jones. And Tamika Jones said she was living in Tampa at the time and that she had spoken to someone she knew that she called Quelo. And that he said he wanted to get at her, that he gave her a contact number. And I believe contact number was her term. And she said she had seen him earlier and that he was wearing a blue vest and cargo pants and that the pockets may have had a zipper. Now, she didn't say Dontae Morris. If you go back and check your memory and check your notes, she said Quelo. And then Mr. Harmon said to her, and all the rest of his questions to her were about Dontae Morris. And she answered those questions. But she didn't say she ever met the person and knew him as Dontae Morris. That's what she didn't tell us from the witness stand. Now, she said the detective showed up the next day and showed her a picture. And she says, well, looks like him because of the shape of the head and similar clothes. Now, here's the other thing about her. She says, he gave me a contact number and phoned me from that number. And from then on, thereafter, in this trial, she said she didn't know whether that was his phone or not. She never saw him with the phone. And the call to her was, I believe, a one-time thing. From then on and thereout through this trial, the state of Florida asserted to you that that phone number was Dontae Morris's phone number, and it was referred to sometimes as the phone number connected to Dontae Morris, and that was it in terms of this trial and where that went on. Now, and Ms. Jones did tell us that she had a prior conviction for a crime of dishonesty. The next civilian witness that we heard from was Ashley Price. And I'm going through this telling you what the witnesses said on their own, because afterwards there was much testimony about what law enforcement said these witnesses said, and that testimony became bigger and definitely more certain, and I submit to you, bolstered by law enforcement. So I am asking you to go back, to go through your memories, to go through your notes, and look at what the witnesses themselves said, what they saw, what they observed. Okay? The next witness we heard from was Ashley Price. Ms. Price said, when she was questioned by the prosecution, saying that before the shooting she saw Dontae Morris day to day or every other day. And she said, but most of their contact was by phone, and that he confided in her. She said she was intimate with him for a period of time, and that she had known him for about a year. And when asked by law enforcement, she said she knew him very, very well. And she said that he confessed to her. And she made it sound as if there was bragging or some sort. So, now mind you, Ms. Price is the only witness who received a financial benefit for her cooperation, and she did tell us that she was then a 3-time convicted felon and that she is on probation and now has charges pending against her. But she says that didn't influence her testimony. Okay? Now, with Ashley Price, when she was cross-examined, she says, well, yeah, there were a multitude of calls. I actually didn't see him day to day. I think I, saw him a couple of times, and I was intimate with him once. And she said that they talked every day, and that was her contact with him. And she told us about a number of telephone calls that occurred on June 29th. She said, he called me at 3:30, he called me at noon, he called my phone many times. And she says, and she gave numbers, I think 5, 6, I don't remember. She says, I didn't answer the calls. Okay? So I questioned her about being a close confidant. It's like, okay, you and he are so close that he'll tell you he committed a murder? So I asked her, I said, well, do you know if he graduated from high school? You're a close confidant, close enough to confess to murder. What did he want to be? What were his career goals? And she says, oh, I didn't like him. She says, she didn't know those, by the way, and she says, oh, I didn't really like him. I wasn't attracted to him. He was too dark. I don't know about you, but I had a hard time.
Objection. Improper argument.
I don't know about you, but I suggest that was kind of hard to swallow since you saw her, and she's pretty dark. But nevertheless, the reason she didn't like him was because he's dark. Now, she finally admitted that in this year that she had told law enforcement she knew Dontae Morris, that she knew of him, and she didn't know him personally, and that her contact with him had been limited. Now, we saw tons, and you know something else? Ashley Price was not asked to identify any person in this courtroom as being the person she knew well, as being the person that she talked to, as being the person who confided in her and felt close enough to her that he would tell her he committed murder, and the person that she had been intimate with. She wasn't asked if she could identify that person as being in this courtroom. Now, you know what else about Ashley Price? All these phone calls every day. We saw tons and tons and tons of phone records. Did Ashley Price say, this is my phone number? Did anyone say, oh, in all these records, this number is associated with Dontae Morris, and these are calls to Ashley Price? Come on, she said he called her 3:30 the morning of the incident. We didn't hear about that. Now, and remember, ladies and gentlemen, what's required in this case is proof beyond and to the exclusion of a reasonable doubt. If you remember, it was Detective Charles, and I'll probably mispronounce his name, Masucci, who obtained the phone records. And he told us, he says, well, it's difficult if you only have a phone number. But as to Ashley Price, he had a name, he had an address, He had times of the calls, dates of the calls, and since she was a cooperating voluntary witness, I can't imagine that she would not give her cell phone number if asked. And Detective Masucci told us, he says, well, you have to get cell phone records quickly because they don't keep them all night long. Well, Ashley Price spoke to the police the next day. I believe it was referred to as a day and a half later. The records were fresh, and they were there. Now, we heard from a number of law enforcement witnesses. Detention Deputy Stephen Gray, Detention Deputy Hector Estrada, Detention Deputy Adam Camara, and Detention Deputy Michael Galis. Okay. And these guys told you, oh, I looked at the video, I listened to it, and that voice is Dontae Morris. And we heard from Detective Henry Duran. He said that he worked at Tampa Police Department for 30 years and that he was retired. And he said he was familiar with the audio and video on the audio and video of the dash cam video. And that's the way he phrased it. Then he listened to it multiple times. And he said he could tell you that the voice on the dash cam video was of Dontae Morris, the person he pointed out, this person who's sitting here in the courtroom. Now, Detective Duran said he attended the autopsies. Not only did he work for Tampa Police Department for 30 years, he attended the autopsies that he interviewed Courtney Brantley. He said there was a command center set up across the street on 50th Street to do, guess what police do at a command center. And he said he visited that command center every day. He said he listened to the jail recordings of Dontae Morris, and he can say that it's Dontae Morris's voice on the dash cam video. Now, these witnesses, they're law enforcement officers. They're part of the brotherhood of law enforcement officers. I'm not suggesting to you that they intentionally misled you. I'm suggesting to you that it would be very, very difficult for a person who worked at Tampa Police Department for 30 years, a person who attended the autopsies of the 2 officers who were slain, be very difficult for that person to be objective. Be very difficult for that person to do anything other than say, oh yeah, that's him. Let's talk a little bit more about this. Each one of those officers was asked if the officer had any training in voice analysis, any training in voice recognition. And remember, what they're talking about is, I listened to a tape recording, audio or visual, and in the case of Detective Duran, he said he did speak to Dontae Morris because he took his buccal swabs. But they're listening to an audio or video recording, and they're comparing it to the voice in the dash cam video. Not an original person speaking, but a recording. This recording and this recording are the same person, and I'm telling you that. Well, let's talk about the detention deputies. Deputy Galis said that he was around Dontae Morris for 4 months, that he went past his cell every day, and that he spoke to him occasionally, and that he heard Dontae Morris speaking to other inmates. Okay? He said he had no training in voice analysis or identification. Detective Camara said he worked in the jail for 2 years. Detention Deputy Estrada said he worked in the jail with Dontae Morris for 1 year. And Detective Gray said he watched live video of Dontae Morris and that he compared what he heard on live video of Dontae Morris to the dash cam video, and the voices are the same. Now, did you notice that we heard from tons of experts, but not a single expert in voice comparison or voice analysis? Not a single person who spoke to you said, I have training in voice comparison and voice analysis. I submit to you that these persons truly believed that they made comparisons and that they did and that they did it objectively. But I submit to you that they're part of the brotherhood of law enforcement, that law enforcement officers have a bond, and that they're close. I mean, law enforcement officers have a memorial in D.C. for slain officers. It's attended by officers from all over. There's a connection, and that connection makes it difficult, I submit to you, impossible for these officers to be unbiased, to reach any conclusion. Remember poor Detective Roy? He broke down in tears. Your job is to weigh through the evidence, to be unbiased, to be the finder of fact, to seek the truth. You have to weigh the evidence, and it's purely your job to decide what evidence is reliable. Judge Fuente will tell you that. Yeah. Remember, the burden of proof here, the burden that's required by the state of Florida, is beyond and to the exclusion of a reasonable doubt. You know, I submit to you that determining whether the voice in the dash cam video, the voice that can be heard, I submit to you that's your job. And that you are the ones charged with deciding that, and that no one else is. I would argue that having people come in and tell you, oh, I heard that voice and it's him, that's invading what you're supposed to do. Okay? It isn't as if any of these people said, oh, that the voice was, well, a husband or wife, a voice that one hears every day. It isn't like they were close friends or relatives where you recognize a voice. And it goes beyond that, because the voice is not a person speaking directly, but a recording. I don't know how sophisticated the L3 system is, but I submit to you that no recording is good enough to capture the, well, sorry, I don't know how sophisticated that recording is, but it's a recording. Right? It's not a direct person-to-person communication of voice. And we have people saying, I listened to this recording and that recording, and I can tell you that those are the same. How difficult would it be to produce, or how difficult would it be to have it analyzed? The state of Florida showed us during this trial that it had samples of the voice of Dontae Morris. We heard through Catherine Polite the setting up of the ability to use the jail system to make telephone calls. We heard that, and you heard the voices. So there are tape recordings of the voice of Dontae Morris, and there's a dash cam video. What we didn't hear was a person saying, I'm an audio engineer, I compared this, they're the same. We heard people who are brothers in law enforcement. Trust me, I don't put that down at all. I mean, not at all. It's something that affects people. I don't have any family members who were directly involved in law enforcement office.
Objection, improper argument.
But that affects human beings. It does. There is communication among law enforcement that goes across, communication and connection, I submit to you, that goes across the lines of, that's your department, so I don't care. That law enforcement's different. That the connection goes across the agencies. And in this case, the people who told you are all local and have that connection. I submit to you that the dash cam video speaks for itself, and that it is your job to listen to it and to analyze it. Now, physical evidence. Physical evidence is different than evidence given to you by a person. And there was some physical evidence in this case. The Camry, it's a car, it's an item, it is. It doesn't speak, it doesn't have a connection to anyone, it doesn't have a bias. The Camry yielded fingerprints and DNA samples. Now, none of those fingerprints or DNA samples from the Camry, and we'll get into, except what was done by Dr. Wall, none of those matched Dontae Morris. And I guess this is as good a time to get into Dr. Wall. Dr. Wall testified today, and he told you that he did some sophisticated tests on regarding DNA from the Camry. And he said that on one sample, I think he said it was Officer Kokab, that the chances were 1 in 10 that he would be included in the people who made that sample. And he qualified it. He said, given that in a random population, 1 in 10 could be included in that sample. And so I submit to you that the 16 of you are a random sample population, and by that analysis, 1.6 of you would be included in the person who left that sample. And he said 1 in 13 was ratio to when he compared that to the known DNA of Dontae Morris. That 1 point, not good at math, but 1 in 13 if it's a random sample. And he was asked questions. Oh, if the population of Tampa is 1 million, how many people? And he came up, and he had to use his calculator, and he came up with 77,000. It's up to you to weigh the evidence. I submit to you that physical evidence gained from the Camry doesn't rise to level of proof beyond and to the exclusion of reasonable doubt. I argue to you that in fact it just about excludes Dontae Morris from having left DNA in that Camry. Now, fingerprints. We heard from the analyst who told us her background and her training, and she told us she's careful and never makes a mistake. And she analyzed fingerprints, none of which matched the known fingerprints of Dontae Morris. We heard about analysis of the firearm. And what was shown to you there is the analyst said, well, what we gained from that was that the projectiles, in this case, were of .38 caliber. And it was presumed from law enforcement, because no one found projectiles, that the firearm used must have been a revolver, because semi-automatics eject capsules, eject the casings. Thank you. But we also learned from the firearm analyst that there are 662 types of guns who use .38 caliber class ammunition. No gun was found in this case. And if you remember, even Miss Keene didn't say she saw a person with any gun, and I forgot his first name. Mr. Thompson said the person who jogged past him didn't have anything in his hands. We know that there was no firearm recovered in the Camry, and we also know from the processing of the Camry that there wasn't any evidence of a firearm being there. We heard a lot about cell phone records. And we heard a lot that one particular number, based on the information of Tamika Jones, who knew somebody called Quelo, that she didn't even say was Dontae Morris, and she didn't say, oh, he told me this was his number. She said, contact number. So after that, that became the phone number of Dontae Morris. But you know what other numbers we heard about? The mystery number, 813-453-7397. If you go back through the evidence, the mystery number on the night of the incident, the mystery number pings off the towers closest to the incident. And it's during the time of the incident, and multiple calls back and forth from that mystery number. And Detective Masucci, when he was asked about that, he says that was an unknown subscriber. He said that it's harder when you only have a phone number. And to the mystery numbers is really, really close in time to the shooting. And some of the phone calls lasted for a period of time, which how could Dontae Morris be answering the questions of the police officer and speaking on the phone at the same time. We don't know, and we can't know at this point, who the subscriber was for that phone number. But what we do know is that phone was active and being used on that evening, and that the calls to and from that phone always originated at the same tower, and that that tower was the one very close to where this incident occurred. Now, Judge Fuente will tell you, and this was mentioned very briefly by Mr. Pruner, that you will be presented with lesser included offenses. We're not conceding that Dontae Morris did anything in this case. We're not conceding that he's guilty of anything. But I have a duty to go through this with you. And in terms of lesser included offenses, Judge Fuente will present to you the definition of second-degree murder, which says that a second-degree murder is an unlawful killing that was by an act imminently dangerous to another, demonstrating a depraved mind without regard for human life. That could describe what you saw in the dash cam video. Two very, very quick, rapid shots. He will also tell you that another lesser included offense is manslaughter, and that manslaughter can be accomplished by what's called culpable negligence. And culpable negligence is failing to use ordinary care towards another person. And he'll tell you that that's not just ordinary negligence. You know, I submit that if I left a puddle of water on my front steps and you came and fell down, that I was negligent for leaving that. But not in a culpable way, not in a way that rises to the commission of a crime. And so he will tell you that you could consider that. And he says, and he will explain to you that culpable negligence is a course of conduct that shows reckless disregard for human life or gross, careless disregard for the safety and welfare of others. And it goes on to describe for a person that culpable negligence goes beyond something that is simple, that it rises to the level of a crime, and that by doing something culpably negligent, that could constitute manslaughter. Then he'll also tell you that Dontae Morris, in this case, is charged with escape while transporting, and that escape while transporting means that a person was in custody, was a prisoner, was being transported to or from a place of confinement, and escaped from custody. I submit to you that in watching the dash cam video, that doesn't fit, that there was no evidence that the person had been rendered into custody such that they would escape. Never in the dash cam video does one hear the officer says, "You're under arrest." In this case, you have been here for weeks now, that you promised and listened and were instructed that it is the burden of the state of Florida to prove its case beyond and to the exclusion of a reasonable doubt, that that standard is higher than what's required in civil law, that it is the highest standard of proof required in our system of jurisdiction, and that what is required of you is that, required of the state of Florida, that proof be obtained beyond and to the exclusion of a reasonable doubt. Dontae Morris, by exercising his right to have a trial, has asked you to weigh the evidence here, to decide the case, and to make a decision based on the law. I submit to you that when you sort out the evidence, considering the physical evidence, and when you weigh the testimonial evidence and consider some of the things that Judge Fuente will tell you, like in speaking of a witness, that was the witness in a position to see and know what, to observe what they say they saw. He will tell you that you can, consider whether the witness had some interest in how the case should be decided. It will tell you that you can consider whether the witness had been convicted of a felony or a crime of dishonesty. And he can ask, and he will also tell you that you can consider whether or not the witness had some sort of financial benefit involved in the case. When you sort out the emotion, sort through the testimony of those well-meaning, and I submit to you, honest officers who truly believe that they were in a position to be neutral and tell you that the voice on the dash cam video is the voice of Dontae Morris. When you sort through the emotion and look for the evidence, that you will find that the state has not met its burden of proof beyond and to the exclusion of a reasonable doubt. And we would ask you to act upon your solemn oath and follow the law in this case, to set aside feelings of personal sympathy and reach a true and just verdict. Thank you.
I remember the jury had been sitting close to an hour and a half. Mr. Harmon has about another hour or so to argue. Does anyone need a break before we continue? Yes, okay. All right, let's about 1:25 to 15 minutes break, 50 seconds. All right. Report to the chair. 55 minutes. Okay, jury, will be seated. We'll be in recess till 1:45.